Hello and welcome to today's webinar, Navigating the Decoding Rise of Deregulation in the US. My name is Jack Halliday and I'll be running today's session. Before I hand over to today's speakers, I'd like to remind all attendees to please engage as much as possible by asking questions. Please message in the chat box if you have any audio or visual issues or questions during the broadcast, and also want to remind you that today's session is being recorded and a full version of the recording will be sent out after the webinar. Without further ado, I'd like to hand over to today's moderator, Shira Brown.
Good morning, everyone, and welcome. I'm Shira Brown, Head of Regulatory Research and Analysis at Vixio Regulatory Intelligence. I'm excited to kick off today's important and timely discussion, Decoding the Rise of Deregulation in the U.S. Over the last several months, we've seen notable regulatory shifts in the U.S., particularly in financial services. Most recently, the CFPB's decision to withdraw 67 guidance documents, policy statements, and rules. For financial institutions and compliance professionals, this signals more than a rollback. It represents a deeper transformation in how compliance risk is assessed, interpreted, and managed. So what does that all mean for your compliance program and forward-looking risk strategy? That's exactly what we'll unpack today. During the session, we'll explore the compliance and risk implications of the CFPB's withdrawals, best practices for navigating regulatory ambiguity and operationalizing policy changes, and predictions for how deregulation trends may continue to evolve and how to stay ready. Before we get started, which should be a very interesting discussion, I wanted to give a brief introduction of what we do at Vixio. We are a reg tech company offering independent, authoritative, and actionable regulatory intelligence for compliance, regulatory strategy, and development. We help you understand the impact and opportunities for your business so you can stay on top of the regulatory change to meet your obligations and identify growth opportunities. And for me, once again, I'm Shira, the Head of Research and Analysis for the Americas. I lead the development of strategic content and regulatory insight, and I bring a wealth of experience to Vixio as a former bank examiner at the OCC and consultant. I will now pass over to our speakers. Allison?
Sure. I'm Ali Schoenthal. I'm a co-chair of Goodwin's Banking and Consumer Financial Services practice. I'm based in New York, and I handle litigation and state and federal enforcement in the financial services space nationwide.
Okay, thank you. Sherrod?
Hi, my name is Sherrod Wilkerson. I am the former Chief Compliance Officer at the First Bank, and I oversee all regulatory initiatives.
Okay, thank you. Ravitha? Sorry.
Hi, I am Revathi. Revathi Jose, and I'm in-house counsel at JP Morgan Chase. I focus in mortgage servicing, and in the last few years, I've really focused in the loss mitigation space.
Okay, thank you. Chris?
Good morning. I'm Chris Garvey. I'm in-house at Fifth Third Bank, and I lead the team that handles litigation and regulatory enforcement bank-wide.
Okay, thank you. Matthew?
I'm Matt Underwood. I'm the Deputy General Counsel for the Consumer Bank at Fifth Third, and I lead a team of attorneys that support the various consumer lines of business that we have at the bank.
Thank you all for being here. Disclaimer, the views of our panelists are theirs and do not represent their employers. Let's jump into our first question. Our first question is, how long did it take you to get through all 67 pieces of guidance? You don't have to answer, that's just a trick question, but just to kind of just speak to just the volume of guidance that was issued, it was 67 pieces that just kind of came out over a day. It was really a lot to go into. And so I just want to go into 4 areas of kind of highlighting it, which is how this impacts compliance programs. There were 13 advisory opinions that were withdrawn that provided clarity on such things as definitions. And so just kind of knowing that there was a various different levels of guidance that was giving out. How are the institutions distinguishing which rescinded guidance still has practical relevance for them?
So I'll take that. I'll take a stab at that, Shara. So, I mean, so we've been, dealing with rescinded regulations for a while, never to this volume. And so when we think about the sheer number that came down, we have to look at it from a risk perspective. And so we've looked at, taking that first swath and tried to understand what regulations are actually impacting us and what have we done relative to when some of these regulations, this guidance, let me call it what it is, guidance, was relevant to us. And we're looking at each one and we're applying kind of a risk-based approach to whether it's a product, a process, and almost, what do we want to be when we grow up? So that would be how we would approach it.
Okay, thanks.
I'm happy to add to that I guess as the only outside person here, we did look at all the 67 documents. Have a little cheat sheet chart if anyone would like it, happy to pass it along. But we also looked at what remained, which is like 20 plus guidance documents. But in the end, it's just guidance, right? It's not a rule. It's not a get out of jail free card. I think some companies might feel a little freer to resume or continue a practice the CFPB frowned on, but I don't expect a majority of companies to change course or overhaul their compliance just because the CFPB rescinded some guidance documents. And you also have to recall that after Chevron and the Supreme Court's Loper-Bright decision, the rescission of 67 guidance documents might just have a limited practical effect. The laws remain the same. The courts are left to interpret them. They could interpret them the way the CFPB said in the guidance, and they might not. So I don't know that the withdrawal is definitely a signal, but I don't know that it changes compliance practices.
And I would agree. I think a lot of times with guidance that comes out, even when it comes out, there's a risk-based analysis in terms of to what extent, if it provides some more leniency, to what extent can we really rely on it? Because it is always subject to rescission. If it's a blog post, it can be deleted. So there is always a certain risk analysis that goes into it, even when the guidance comes out and you're thinking about to what extent to follow it. To the extent it provides a more restrictive view, I think it can be informative of how the Bureau, how the agency is looking at things, and it's helpful. But at the end of the day, it's not official regulation or law.
I would agree with that. And I guess kind of just piggybacking off of that a little bit, are there risks for firms that actually act as if the guidance still applies, in your opinion?
I can take that one. I don't think there's significant risk because, like we've all just been saying, this is not binding law. This is just one interpretation. And there's no reason to say that that is an incorrect interpretation per se, absent any regulation to the contrary. So I think it's really hard to measure any risk and say, if I continue to comply with this existing advisory opinion, then I am somehow creating more risk for my company.
And
Thanks,
I think it's important to, I agree with everything everyone said before this, especially the fact that this is nothing new and has been anticipated, although it's on a little different scale. But, the law and the regulations remain in effect. We have one agency, that seems to be retreating, at least temporarily. There are others that are still out there, especially for those of us who are in banks, OCC, Federal Reserve, what have you. And the law and the regs are still in effect. They set minimum standards of conduct. You can always do more regardless of guidance. There was guidance that had been rescinded, invalidated under Congressional Review Act, and yet still, there are banks that have done away with or pulled back from certain types of transaction fees, overdraft fees, what have you, that you see in the market. And so it really, I think, Revathi said it right. It's risk-based. And taking care of your customer, making sure you have a culture of compliance, and the interpretations are just one piece of it.
Yeah, I would agree with you, Chris. And I think it's important just to note here that, every bank is going to be different. So I think, as a compliance professional, that, it's your, job to, determine what that risk is for you and to take that, whatever approach you want to take with that, to come with that approach, that best fits your bank. In terms of just best practice for managing regulatory uncertainty, because I think, just at the pace that the, rollbacks have come and just changes, within the first 100 days of this administration, it does feel like there's a little bit of uncertainty there. What best practices would you recommend for staying agile during regulatory uncertainty?
I would go with, you have to track all the regulatory developments, which is almost a full-time job. I think you need good open communication with your regulators, so that when things come down the pike, you're in a good position for it. If you're changing internal controls, you're going to document it because the next administration might see things differently. And I think, as Chris said, you got to remember there's a lot of other agencies with enforcement power, and then if you change anything, there's the plaintiff's attorneys off to the side waiting to jump in on that too.
Again, certainly it's nothing new. For those of us who remember back to the mortgage crisis and the foreclosure crisis, a decade or more ago, the pace of change of, defaults, mortgage servicing and the like that was happening coming out of the government at that time was, dizzying. And I would say, probably as frenetic as maybe what we're seeing now, and created, and just like today's pace of change will create real sort of operationalization risks. So really, I think what Allison said, keeping on top of it, communicating, trying to find the through line, but also I think you're going to have to be a little patient and see where the story ends. Because if you are just reacting every single day, you could find yourself in a difficult situation.
That's a good point.
Yeah, I might also add, I agree an alley as it relates to some of the regulatory change management. I would encourage, banks to have, if they do not already have just a robust regulatory change management program that documents not just the change, but the rationale for the change. Because quite frankly, if my number comes out tomorrow and I'm gone, because, I got a couple of commas behind a zero, somebody needs to know, really what the rationale was behind why we didn't make a change or we did make a change. And like to Chris's point, when we think about what happened in the mortgage crisis and then the servicing of during COVID, this is a withdrawal of guidance. During COVID, it wasn't a withdrawal. It was an avalanche of this is what you must do. And we're talking just about the CFPB here. During COVID, we had 4 or 5 regulatory agencies that were having conflicting. And so if we take our lessons learned from that and begin to apply them here with understanding and the transparency and open communication, I think that all of that combined puts us in the best position to navigate this.
I would add one more point on that. I think especially in light of the withdrawal of these 67 advisory opinions, interpretive rules, etc., I think the states are going to be very quick to try to fill the gap and try to pass legislation very quickly to make up for the lack of CFPB enforcement, if you will. So I think now it's even more important probably than ever to have the regulatory change tracking every state that you do business in, to just be very careful to pay attention as laws are changing.
Yeah, I would agree. I try to track all of these changes, and I feel like no matter what I do, I'm always behind, because by the time you've digested something, either it has changed or something new has come out that's a whole new kind of worms. So I would agree with what everyone has said. Just tracking all of this it's a full-time job, not just for one person, but I think for several people. There's a lot going on, and I think to Matt's point, both at the federal level, and I think we're starting to see more activity on the state level as well, which just adds a whole new layer of issues to deal with. And I would agree that open communication with regulators, and I think also really leaning into your government relations, your GR team is going to be helpful, because to the extent that we can get ahead of state level changes or other changes that are in the pipeline, I think that can really be helpful in trying to avoid significant problems. Dealing with it after the fact is always harder, right? So to the extent we can develop those relationships and try to inform them in advance, I think that can be incredibly helpful as well.
I think you guys sorry about that. I think you all guys brought up a couple of different points I just want to unpack just a little bit. I like the fact that, Chris, that you brought up the fact that, with the mortgage crisis that we had, like I said, almost a decade ago, the uncertainty of kind of, new regulation coming out that wasn't, if you've been in compliance, you've been in the space for, at least over, 10, 15 years, you're used to it from that standpoint. And I think, just kind of remembering, how we approach that, those uncertainties. I think, Sharad, to your point, about during COVID, where, it was coming from multiple different agencies. And I think, from the deregulation part of, the federal government rolling it back, and then the states, now, coming in and stepping in and doing a little bit more. It's kind of going to be the same thing, just, making sure you, maintain and understand, who actually your regulators are, who you actually have to answer to, in terms of, with the states coming in and how that actually works out for you with, various different AGs coming into play. But I think those are very good, valid points to bring up. And then it kind of rolls into the segment of, just the regulatory change management, ensuring that you do have a really strong program, especially in this environment. Some institutions still have a very manual process. I think, having an automated process will also play into that and help with that as well. I think we then kind of led into our state kind of aspect of just kind of speaking to like the role of the states in the deregulating the federal landscape. How do you guys foresee state regulators stepping in, and what's the compliance risk of a fragmented regulatory landscape? Keeping in mind that also a part of some of that rollback were two interpretive rules as it relates to the Fair Credit Reporting Act, as well as the authority of states to enforce the Consumer Financial Protection Act of 2010. Anybody want to take that question?
I'll take it from the litigation perspective, because that's where I sit. But in the last term, really the Administrative Procedure Act, Chevron, and Loper Bright, and the major questions doctrine all had their day, and many people became experts in those very arcane niche areas of law. I think for those of us at national banks, national bank preemption is probably going to have its day, although the way it was codified into Dodd-Frank is a very facts and circumstances type of analysis, so that it's going to be fragmented. But once again, this is not something that is new. We have states that have data privacy issues, rules and regulations and laws that are far stricter than other states or the federal standard. I'm looking at you, California, right? And whether we can all operationalize to multiple standards, or if you have to operationalize to a highest or lowest common denominator, are all issues that we're already grappling with. I think what's the watchword of today is simply uncertainty. We're not, it seems like we've been at this for a very long time, but I was at some other briefing yesterday, and they're only 120 some odd days into this administration. So the pace of change has been extraordinary. The reaction from the state AGs and other state regulators and the like has been robust, but it is still evolving. So it's, if we were to use a baseball analogy, maybe we're in the second or third inning of this, maybe. So it's going to put a premium on, as we've talked before, monitoring reg change management, communication, both with your regulators, but also externally, and then evaluating opportunities, I think, especially for national banks, where preemption and make preemption arguments, and maybe leading on trade associations and the like. But it's going to be interesting. It's going to be an interesting ride for a while, I think. I'm sure Allie, as outside counsel, knows that she's going to be busy.
We like busy.
I would also add to your point, Chris, as you and I talk about frequently, especially in light of the withdrawal of the interpretive rule about the state attorneys general ability to enforce the CFPA. Yes, that was withdrawn, but the states will still have their own view of that. And I think we will see a lot of litigation, especially if you're a national bank, on the preemption front. Certain laws certainly are carved out of the National Bank Act, and it's going to be a tough battle. If you're a national bank, if you're a state bank, then, best of luck to you. But I think we'll see a lot of litigation on that front.
Right.
Yeah, and I might add,
And it's tricky, right? It's not like necessarily a slam dunk with preemption. It's a murky space, and it's a cost benefit analysis. It's a very case by case specific analysis. So oftentimes some of these things come out, these state laws come out, and one of the first questions I get is, well, aren't we preempted, right? And it's the answer is not an easy yes or no, even though we would like it to be sometimes, but it's complicated. And I think we're seeing like indications even just from the Bureau, right? Like the current CFPB has indicated that they're moving away from certain supervisory and enforcement activities that I think they said that are better left to the state. I mean, that's a clear indication that they do want the states to step in, which is I think is really interesting. And even in the prior administration, right before Rohit Chopra left, I think they left a sizable playbook for the states to follow. So, I mean, even whether it's the prior administration or even the current administration, I think we're seeing some indications that there is an expectation for states to pick up wherever the Bureau is choosing not to go. So it will be interesting.
And I think that kind
and
of
I also think, I was going to say, I think also everybody's been talking about, when we're thinking about if the states come in, the preemption argument that has been going on for years now is going to come back to the forefront. The uncertainty, whether it applies here and doesn't, that can of worms is going to be open. And there's a reason why we have swivel chairs now, where we have to just look everywhere instead of having standard chairs where we're just focused on this. So I guess prepare for that.
Yeah, I was going to add to your comment of just, with the playbook that was issued, as well as, what we're seeing in some of the press releases that are coming out. It kind of plays into, every other outside of financial service sector, but other areas of like where the administration is pushing things back to the states. So I think, pushing consumer protection back to the states kind of just plays into that as well, of kind of just how the administration going. I do say what is a little interesting is where you see, I think it's with the AI part of where they're saying, the states can't kind of really govern that part. So that is interesting as well, of where they're kind of picking where they kind of want to push that back to the states. Allison, did you want to add anything to?
I was going to say, I think this is why people outside our industry are always surprised to hear that the financial institutions actually want a CFPB, with a big asterisk of like, with limited scope and authority, but at least some kind of coordinated regulator instead of the fragmented different states. I do think you already seen some of the states step up. I mean, some of them have historically been consumer focused and focused in this space. New York, where I'm sitting, Massachusetts, Illinois, California, that Chris mentioned. But you've also seen some that have already enacted legislation, and particularly in UDAP, which is like a great enforcement mechanism for them expanding their authority. I think this month, Maryland's goes into effect, where they expanded UDAP to unfair and abusive. Virginia goes into effect next month. Ohio had the expansion of their Consumer Sales Practices Act. And our New York Attorney General, very focused on this space, has introduced the Fair Business Practices Act of 2025 that takes our Deceptive Practices Act and adds unfair and abusive to it, and a whole bunch of other changes, happy to talk about. But, it's the way the states are all having different rules that they already have and then expanding them. And it's going to be a lot to track and to comply with.
And I think UDAP in particular can be a bit of a moving target. And having one bureau with a single set of interpretations, whether we agree with those interpretations or not, having it be centralized can be helpful. Whereas I think having a variety, like the state stepping in and a variety of views and interpretations can make everything all the more challenging.
Yeah, I think New York's a good example of that, turning a Deceptive Practices Act into unfair and abusive, which is a Consumer Practices Act that's now going to apply to business. That you used to have actual injury and now you only need a substantial harm. It's just completely different. It tried to track Dodd-Frank, but it's also expanded beyond that.
Yeah, it's a great point. That you hear in financial presses, markets like certainty, hate uncertainty. Our clients, same way. Give us a rule, make it certain, figure out how to comply with it. The upheaval, the change, the regulatory whipsaw that Justice Kavanaugh pointed to in one of the Chevron type arguments in the last term is real and has creates risk, it creates uncertainty, it creates cost, and it's again, as Shira said at the very beginning, it's nothing new. It's been with us for a very long time, and it continues.
It also creates mistakes, right? Like if you had a system that's
automated,
automated,
right?
Yeah. If you looked back at most of the CFP consent orders in the past, it's because something was automated, and then something slipped through, or because you did all your testing, compliance, you made sure everything works, and then someone switches something, and you end up with a mistake that is now an enforcement action.
Yeah, and that's normally what you end up seeing is, like you said, it's the automated process where there's that slip that maybe gets through on there oftentimes. Chris, were you going to say something?
Saying that that's absolutely true. Hopefully, we're going to see a little less of is something that I think we all know is something that we've all been interpreting to comply one way, and then this interpretive guidance comes out and says, sorry, that's not the way it's supposed to be done. You've all been doing it wrong. Examinations are launched, or one member of our industry has to announce an enforcement investigation, which is designed to put the industry on notice that the old way of doing things is no longer the way that it's going to be accepted and tolerated. So hopefully there'll be a little more certainty and predictability, at least the next couple of years on that front. But even then, we don't know, because as the others have said, state AGs are going to try to inject their views of the world, and then they already are. They've already done it, even for enforcement actions that have been withdrawn. Some states have withdrawn. So certainty that we might crave might elude us. Certainly is so far, I think.
And then in terms of
I think we're using words stability, certainty. Those words, to Chris's point, I think they're non-existent in our environment. This is what we live. This is what we work for. We're always sitting at the edge of our seat. What's next? And we think about automation. So and just technology. I think we also need to be careful that we're still agile enough. Just because you have technology does not mean that you're agile. Sometimes it takes a lot of effort to change some technology to ensure that you're staying within your risk tolerances as the walls are caving in and different regulations or guidance is causing operations within the bank to go awry. And so I think making sure that if we're going to go the AI route, which is probably where if we're not there, we need to be there to help us, making sure that we're still able to be agile when these uncertainties happen within the industry.
No, I would agree.
Yeah, that's
with
a really good point. I think, we're having worked at large banks, the technology can both help us, but it's you talk about bureaucracy at large agencies, but technology is part of that, right? Building systems takes a lot of resources and time and effort, and then trying to change those systems or unwind those systems to build something new, it's an enormous undertaking sometimes, and that can be really difficult to do in any sort of a quick fashion. So yeah, I think that's a really good point.
I think just even to add to your point of when I was in testing, a manager for monitoring and testing, oftentimes when you have it, you find something, you just automatically assume it's a quick fix, and then you find out as you kind of unpack that it's not as a quick fix as you think, because of the technology part. That even as an examiner, we think when we tell, I would think as I tell somebody they need to change this on even just a disclosure, you think it's a quick fix, and actually when you kind of fall into the technology part, it takes a little bit more to just change things. Than we actually think. But I think it's the part of being agile and realizing and going through that process of determining the risk and what needs to be done, kind of the risk assessment, the impact assessment before actually, incorporating that change, also kind of plays into it. I think we talked on, just the role of the states, deregulating, the federal landscape. Let's go ahead and get into a few audience questions. Okay, looks like we have two questions that came in. The first one is, what should compliance leaders prioritize in the next 6 to 12 months? Anybody want to take a stab at that one?
I'll go with relationships with regulators,
I can take
tracking changes, cyber risks. I think that's going to be a big area. And always considering the vulnerable populations, which I think is kind of the low-hanging fruit for regulators to look at. So service members, veterans, elderly, places where there's tangible harm or, God forbid, intentional harm. Those are the kind of things that I think regulators will continue to look at.
Yeah,
I'm interested in what you all are telling your compliance leaders.
I would completely second what Ali said. I think, as we've been discussing, that the changing landscape of the state environment and regulations and laws, you need to pay very close attention to. And it is such a murky gray area. I think I would also say what we tell our compliance people is, when it's a gray area, make sure you do the right thing for the customer and remediate problems, err on the side of the customer. And almost every time you're going to be right. So that's kind of what we're looking at in this short 6 to 12 month environment.
That's always interesting, because I always feel like you need to treat customers the same, right? And no good deed goes unpunished. So that is, you always want to do right for the customer, but do make sure you're treating them all the same.
Mm-hmm.
Right.
Otherwise, that's its own problem, right?
Right.
That's the difference, part of the analysis, right?
Yeah.
And then, yes.
Yeah.
Right. And I think it kind of rose into the, especially when you're going to have.
I would echo those.
Oh no, go ahead. Go ahead, Sharad.
Yeah, I echo those. Both by Matt and Ali. The transparency, with the board is going to be crucial. And also, when we think about consumer harm, that being the forefront of any decision that we make with reliance on compliance. And I include that, even now, just in general, compliance having a customer-centric applicability. And so that we're taking those into consideration. And then finally, if legal can't defend it, we're not doing it. And if we're going to make a change, let's stay in the middle. Let's not be an outlier at the same time. So that's, the message, I think, that should be top of mind along with everyone else's messages there.
Okay.
I think one thing I would add is, for the past few years, we have been in a reactive mode, right? Things are coming at us and we're just sort of reacting. And I think that there was a hope. I don't know if we'll ever get there, but my hope is always that at some point we can try to get ahead of some of these things and, take stock of what we're doing, try to identify gaps in our processes and try to fix those and address those before it becomes a regulatory issue. That's something with all the changes that we have now. I don't know if that's a pipe dream, but it's still something that I think we should all endeavor for at the very least. I would agree. Someone said, you should, think ahead. Think of, who do you want to be? And I think that's a big part of it. Like, as an organization, we have certain values, and those values shouldn't necessarily be changing from administration to administration. Just because the political landscape is changing doesn't mean that you're just going to jump on whatever wagon is out there. That doesn't mean that things can't get more difficult as change occurs, or that your strategy might need to change as those things occur. But making sure we keep our values at the central point of everything we do. To the extent there are changes, why are we changing them? Is this change consistent with what we as an organization stand for and what we as an organization want to be over the next 5 to 10 years?
Thank you, Rebecca. It's a fantastic point. Often me and my team and our outside defense lawyers are defending the company, either to plaintiffs' lawyers or regulators, and increasingly state regulators. And the presence of robust core values, company code of ethics, a robust compliance plan, a robust auditing plan, the functioning empowered lines of defense is an extremely important piece of how you defend the company. Allison talked about unintentional, God forbid, intentional wrongdoing, right? Those empowered pieces of your risk management framework are what try to limit those instances that we're concerned about. And if we are called to defend the company ever, that those pieces are still in place, functioning strongly, adapting, empowered, and the like, is something we point to in the defense of every case, in the discussion with every regulator, plaintiff's lawyer. They don't really want to hear it, but judges when they're mediating, juries if we have to point out that we are, bank committed to doing the right thing by our customers, that the regulatory framework, is a minimum, but that we're taking care of our customers. And so it's very important that those areas continue to exist and continue to be robust, and as best they can adapt with the turbulent times.
Yeah, I would agree. I definitely like your point, Allison, that you made about just service members, elderly, just making sure that you have you're making good decisions when it comes to those particular individuals, especially because if you look at some of the press releases that have come out, the executive orders, it seems to be that that's kind of going to be where the focus is going to be in service members. When you kind of say, what the CFPB is going to be focusing on, that kind of seem to be like where they're going to kind of be leading a little bit of focus there. So I do like that point that you brought up about that. Another question that we had, which we touched a little bit on when we were talking about the states, but what states are emerging as leaders or more aggressive actors in the vacuum? And I'll kind of also just add a little bit to that of, are there any states that surprised you that they've stepped up that, historically maybe have not had that much of a voice in kind of the place of consumer protection that have actually kind of stepped up?
Well, I sit in New York.
I'll share one that's not.
Yeah. Good. I want to hear yours, Rachel.
No, I was going to say I have one that's not surprising to anybody, and it's New York, right? Like they're doing quite a bit, and I think several formal. I don't know about several, but it sounds like former CFPB staff have found a home in states like New York, and are continuing their efforts over there. But we've seen a lot of activity there, and I think that it will continue to. Sorry, Allie, I didn't mean to.
No, I was going to say,
thunder.
New York, we're sitting in New York. Yeah. New York, Massachusetts, California, Illinois, Pennsylvania. I don't think any of them are surprised to anyone. I do think you have to remember, we talked a lot about the New York, or just the AGs generally, right? And the activity there, but the regulators in the states too. So, for us, our AG is very proactive, but so is the New York DFS. And unlike a lot of other states that are trying to, or you think might step into the void of the CFPB, New York actually has the resources and the personnel to do it. If you're on Twitter or X, they're constantly hiring, and like you said, they did hire someone from the CFPB. And a lot of people thought that everyone from the CFPB was going to flood to the other states. It hasn't really happened, but New York did take someone pretty high up there for their consumer area. But I think also New York tells you what they're interested in. And I think that's important to look at for each of the states. So our AG, is vocal. So is the DFS. It talks about, its interest in cyber, its interest in crypto, unfair practices, bank supervision, things like that. So I think I'm not surprised by any states yet, but I'm curious if other people are.
Taking it back a step, I think, as you talk about, singing the CFPB, but there's so many other regulators out there, both federal and state. And, there are some issues that are simply not partisan. Fraud at any level, third party fraud, as Ali might say, God forbid, first party fraud, right? Um, uh, Compliance with BSA, AML, KYC regulations, sanctions, all of that. Everyone's going to take a dim view of that, not, in my opinion, going anywhere. And we'll continue to see that if, in fact, there are violations or issues in the recessive pre-com profile in the next couple of years, a couple of different industries. I agree with you about your statements, but I think about the states that are stepping in light of the sort of shifting CFPB's remit. I think, an important, be interested in the panels, my fellow panel members' views on this. The past 5 years or so, or maybe a little less, there's been a separate level of, consumer protection investigation that we haven't seen before, revolving around certain states. Laws about debanking and other initiatives that take it in a direction that we heretofore may have been unfamiliar with, but pose a different yet equally important risk. And I think those, we saw them in dribs and drabs over the last 4 years. I think it's something that we could see more of. You hear pronouncements not dissimilar to the blog posts that we heard in the last administration about these things coming and investigations being launched, or linking the presence or lack of presence of certain programs to False Claims Act type investigations as a different level of risk that we're going to see, but maybe we're not as familiar with. And when we're talking about the continuation of a different playbook, but I think there's also new playbooks that we have to be aware of and go to, and making sure we're on top of this.
That's a really good point. I will say I hadn't even heard of debanking until not that long. I didn't know what that was, and now we've seen a few states have come out with debanking laws. Tennessee, Florida, and recently Idaho, and that is something we're watching and preparing for, because right now it's in a very small, not even a handful of states, but it could get more traction in other states. So building for that is interesting. Sorry, Chris, go ahead.
No, I was going to build on what you're saying. I think if you talk to a lot of professionals in the space, they say, what is so-called debanking? There's morality struggle. There could be intentional, God forbid, debanking, for no good reason, or there could be, perceived debanking that is a result of compliance with existing KYC, and other types of risk frameworks around existing regimes that people may interpret one way or the other. So I think we're going to. The predictions are we're going to see more of that. I don't know that we've seen more of it yet. It's something to be on the lookout. Things that all you can do at this point is highlight the risk for your example. They were saying the thing, hearing you, Sherry. So what should a compliance officer do? Be aware of it. Comply with existing laws and document documents, right?
Yeah, I think that's kind of the theme is the document, and I think just ensuring that it is a clear audit trail of why you made these decisions, so that whether you have to explain it, a few years down the road, or somebody else comes behind you and they need to know why you made those decisions. I think the documentation part is really key. And I have to agree with you on the debanking. That kind of is a newer term for me, at least how it's being described now. Compared to what I thought debanking was, is a little bit different for me. Anybody else want to add anything just about the states and who's kind of emerging from an aggressive before we move on?
I would add on the debanking front, I think in light of the executive order on disparate impact, which says that disparate impact isn't a viable legal theory for discrimination, I think we will see more investigations and enforcement in the fair lending context, and I kind of group debanking with that concept. So I think that is certainly something that we'll see in the coming years as well.
Yeah. Something else I wanted to circle back around that, Allison, that you brought up, just in terms of New York and their AG and then their actual regulator. Can you just elaborate just a little bit for somebody who may not be familiar of the difference between the two, and how somebody who may not actually have a presence in New York can still end up finding themselves, under, having to address some of these, laws and regulations?
I think, like every state, we have our attorney general who has spearheaded some of these changes, like the FAIR Act, and our Department of Banking, our Department of Financial Services, like other states, or like the DFPI in California. It also regulates, if you're licensed in New York, you're following their regulations, and can be subject to them. And I think part of this, like, defragmented that you mentioned right up front, is that they don't necessarily work together. Whether someone can have the AG of interest and someone can have the New York DFS of interest, and it doesn't mean there's overlap there, which I think is one of the problems in the void of the CFPB, is that you don't necessarily have coordination amongst all the different agencies. So, and that's a good example of it.
Okay, thank you, Allison, for elaborating a little bit more on that. I think for me, one of the interesting things I think just has kind of come through our conversation that we've had is somebody who, was in compliance when the CFPB was established, of just like the push of the CFPB coming in. Nobody really wanted to see them come. And then, given, I think what they've done over the past couple of years, have just, you now are hearing people say that, there is actually a purpose for the CFPB, that I think maybe, if you just kind of go back a couple of years when it was being created and kind of being pushed out, that nobody really saw that value maybe in the CFPB, that, actually now you're actually kind of seeing a little bit of that value now, as we're seeing a deregulation of some of these consumer protection laws, regulations, guidance.
Well, they're not gone yet, right? I think everyone thinks they're disappeared, but there's actually, I saw it the other day, there's a hearing in the House at the end of the month on the CFPB, and you can imagine, what the testimony might be, but it's still alive and kicking. So I think we'll have a lot more to discuss on that going forward.
Yeah, and I think you also brought up what you just said brings up a good question. I think we've been saying, but the fact that the law itself has not gone anywhere, it's more of the guidance. I think is just what people need to remember if they maybe are just getting a little excited about what you're seeing in the news and what's coming down, because it's coming so fast and rapid, that, the law itself has not gone anywhere, for a lot of these areas. So I think that also is important to just keep in mind. I think we're almost at the end.
Sorry. We talked about this yesterday in our prep, but for all of these agencies that are statutorily created, and you can gut them, maybe you can gut them, you can't make them disappear, maybe you got an act of Congress, they exist, they have statutory powers. The administration that is in power has their hands on those levers of powers and power, and could use it to act regulations, propose regulations, put them out for notice and comment, and not just negate prior policy agenda, but could enact an affirmative go forward policy agenda with regulations that then, when we're here in 4 years or 8 years or whenever, the wheel may turn and you say, well, this has all been rescinded. We might give the exact same answer, which is, well, the laws and the properly promulgated regulations are still in effect. We still have to comply with them. So that's something that may come later. I don't know, Valerie, you have perspective on that and the interest to sort of operate those knobs of power. But theoretically, at least, it exists, and there is an agenda that can be enacted through having agency over this agency.
Right, that's a very good point. Go ahead,
I was going to say, I think, everyone for a long time was focused on the CFPB because they had nationwide authority. I mean, they could put you out of business, right? It was now more fragmented. Everyone's nodding like that's scary. Now with more fragmented state authority, it's state focused. So it doesn't have that nationwide impact unless they get all together into a multi-state. But there are other regulators, like depending on who you are, it's the folks who had authority before the CFPB, the FTC, the OCC, the AGs could all get together. So there's still a lot of regulation out there, even if the CFPB is not active.
I think for a while we kept getting questions, is the CFPB dead? And I remember I actually took a terminology from the CFPB itself. They've coined the term zombie dead, and I feel like we might be dealing with a zombie agency where they're not dead, and they can, and I think they will come back. So keeping that in mind in terms of however you're handling your internal operations, there are other regulators on the federal level, there are state regulators, and the CFPB is not dead. So
we're going to 12 more trailers.
As we, I guess, go ahead and kind of just wrap up where we are, I'm going to just give a quick lasting impression you just want to kind of leave just based on our conversation that we had. I'll start with Matt, if you just want to kind of give us just your last point, if, a takeaway, your last takeaway is what I want to say just about the topic.
I'll keep it short. I would say pay very close attention to the states, the laws and regulations they're passing, and what their regulators and AGs are doing.
Chris, you want to jump in with your last takeaway? Chris, we can't hear you.
Said buckle. Certainly, we're going to have to just be comfortable with being uncomfortable.
I like that one. That's a good takeaway of basically buckling up, being comfortable with being uncomfortable. I like that one. Allison?
I agree with Matt and Chris so far. So I'd say I'd love to get together and chat again in 6 months and see what's changed then. And then in 4 years, look back at this and see if our predictions were right. But there's a lot going on. You just have to be very on top of it and, take whatever resources you have to stay on top of it.
Allison, I'm going to hold you to that. We'll regroup in 6 months.
Sharad? Drinks or coffee. Yeah.
Right. Sharad?
I would stay vigilant, hold on, and keep your head on a swivel. We're going to be in for, a ride. I'm sure things will emerge out of this that we haven't seen yet. This is a continuous emerging environment. So it's just, stay vigilant.
Yeah, I would agree, especially because we didn't really touch too much on the innovation part of it. In our conversation, that is a word that I keep seeing in a lot of things, whether it's the executive orders or just anything else, as it relates to some of the, consumer protection areas of just the innovation and how that plays into consumer protection. So I would agree with you definitely, just on that one. Ray?
Revathi, you got it. So yes, you've nailed it. So that's great. So I would agree with what everyone has said. We need to stay on top of things. Like even if you're behind, try not to get too far behind because things are constantly changing. And I think to the extent you have any sort of power to shape things, I would say try to take it. I mean, we can sit back and react and complain. I know I do all the time. But I think that to the extent we can try to get ahead of things, that I would take all of those opportunities whenever they come. And I will say I personally need to take Chris's advice because I need to get comfortable with being uncomfortable because it's difficult. So I will buckle up for sure.
I need to take my own advice too.
Chris, I think you created the tagline for our webinar with that one. And then I think just to kind of summarize some of the things that we came up with or discussed, that really stood out was just, I think, in terms of just the change management, making sure that you do have a really strong change management process. unfortunately, if it's still manual, beefing that up, making sure you get that, to where it needs to be so you can keep up, because there are a lot of different players in this space, and new ones that are going to be added as it relates to the state. So just, making sure that you keep up with your regulatory change management. If you can automate it, that's really great. But if you, for whatever reason, have to keep it manual, just making sure that, you are catching any gaps that may be coming in with that, because it is going to be coming in at a fast pace, as we've seen just, in the first, not even first 100 days of this administration. So that's my kind of takeaway from the conversation. I thank you guys. You were a great panel. I enjoyed this conversation and discussion with you guys. If anybody wants to learn more just about Vixio, or you want to continue the conversation and you didn't get your question asked this time, please feel free to just drop that into us, and we can, come back and circle around to some of your questions that you may be having. Thank you today, and have a great day.
Thanks all.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you again to our panel of speakers for an engaging discussion, and thank you for attending today's session. As mentioned at the start of the broadcast, this webinar was recorded and a video will be sent out to all attendees in the coming days. If you asked a question during the broadcast that was not answered, a member of the Vixio team will look to get back to you with a reply also in the coming days. And finally, if you have any questions about anything discussed in today's webinar or would like further information, please email info@vixio.com or visit our website vixio.com for more information. Thank you again for attending today's webinar.